Well, it's good to be with you this morning. A couple of things. One, an indictment is a one-handed account from the prosecutor. If you look at the history of Jack Smith, he did a railroad job on Bob McDonald, the former governor of Virginia that was overturned by the Supreme Court. He did the same thing in another case, high profile, overturned. So I'm reading his account of what's happened and looking at his track record. It's dubious to begin with. Number two, if you want to talk about some of the aspects of obstruction, you got to understand that under the Presidential Records Act, the president does have authority for about a 5-year period to dictate what actually goes back to the National Archives. His attorneys were going back and forth at the National Archives. Number three, somebody at NARA said they wanted to go to the Department of Justice. The Department of Justice had to get a sign-off with the White House counsel before any of this could even be started. So do I look at this very dubious when, by the way, I also know, being a member of the Oversight Committee, that Joe Biden, that there are major allegations that he took $5 million from Burisma? Yeah, I am very skeptical of this indictment.
Understood. I actually want to start with your point number two here. Presidential Records Act is never mentioned in the indictment. There's nothing about personal records here. The indictment is based on 31 documents that are the purview of agency. They come from agency documents. And no matter what the president says or does once he leaves office, this would not fall under the PRA in any way, shape, or form. So I guess what I'm asking about here is these specific documents that are national security information that come from specific agencies and are not personal records of the president. Why do you feel like those were his, not only just to take with him, but then repeatedly keep from both NARA and prosecutors and the FBI when they asked for them repeatedly?
Well, two things. You say the word repeatedly. We don't know that because you weren't involved in those negotiations with his attorneys, and neither do I. That's an accusation from Jack Smith. A couple of things on that piece. The president took the documents when he left the White House. According to wide reporting, his attorneys removed the boxes when they left the White House on their way to Mar-a-Lago. The president's attorneys were also in negotiations with the National Archives, back and forth about what was there and reviewing those documents. And the reason why the Presidential Records Act is important is because the president has the ability to review those records for up to 5 years and has broad latitude to review them. That's why I say that. The reason why they never bring up the Presidential Records Act in the indictment, in my view, is because if you put that in the context of what they're trying to charge him with, the Espionage Act, then it just looks plain ridiculous. Last point I'll make on this. The President of the United States and even former presidents of the United States, they were the executive branch. So to charge them with a violation of the Espionage Act, there is an extremely high bar to do that. And it's not clear if even Jack Smith has that. Like I said, look at his track record when he's charged other political officials, and it didn't cut mustard.
All right, so I want to take just one of the points that you made there, even if you stipulate several of them. The president was only charged related to documents that came after the search of his Mar-a-Lago residence. Everything else before that time, and there were hundreds of documents, that the 15 boxes that his attorneys had turned over, other documents that had been turned over before and after that, were not charged. There was nothing in the indictment related to those, which seems to give the implication that had he just given these back, there would not have been an indictment, or at least not an indictment tied to what we've seen in these 40-plus pages. Do you see, is that something that you would agree with? Is that a stipulation that's fair? This only came, you say that it's just speculation, that these were just negotiations that were occurring. No, I mean, I think it's pretty well documented, both on letters from attorneys, letters from NARA, and also in this indictment. And he wasn't charged on anything that had been voluntarily handed back, even after some of those negotiations.
Look, what I will tell you is, again, I was not in the room with his attorneys when they were doing this. He and NARA are going back and forth. NARA decided probably in the first time of its existence dealing with the former president that they wanted to bring the Department of Justice into this, and the White House counsel had to sign off on this. One other point I want to make. You guys are throwing up the pictures about they were in the bathroom or they were on the stage. As somebody who's been to Mar-a-Lago, you just can't walk through Mar-a-Lago of your own accord because Secret Service is all over the place. So if the documents are in a place, they're in a room, depending on the time of year, you can't even get into said room. There are 33 bathrooms at Mar-a-Lago. So don't act like it's just in some random bathroom that the guests can go into. That's not true. And so I think that when you look at this information and you look at what's come down in the indictment, an indictment is a one-sided argument from the prosecution. The president and his team is going to have an opportunity to respond to this. And actually, in looking at the indictment, one of the things you also have to understand is that there's a lot of context issues here. The context you're getting is directly from Jack Smith and deciding on what he thinks is relevant or not. Until the legal proceedings happen, you can't go through that. But as a broader perspective, let's be very clear that what you see here is a political prosecution of Donald Trump, because former officials of our government who did not have declassification ability and were not the head of the executive branch, they did significantly worse things with material and classified material, and the Department of Justice, previous iterations, and they just basically turned a blind eye and moved down the road. And that is why the American people look at this. They think it's disgusting, and they think it's a two-tier justice system simply to go after President Trump.
Look, your view, and I think the view that reflects what I think Scott Jennings, who's been on our panel, has made clear a lot of Republicans feel based on what they've seen. I think these are very different.
Oh, no, not feel.
No.
It's not feel. Understand this. It is not feel. That is a fact. Hillary Clinton's documents, her emails were subpoenaed.
So tell me, based on this indictment here. They were subpoenaed by the Oversight Committee.
She destroyed them. Joe Biden took classified material as a United States senator. I'm a United States congressman. I am not allowed to remove classified documents. He took them as a United States senator. They were all over the place. That is a violation, actually, of the Espionage Act. And so there's been no talk, no dissemination, no investigation of any of those things.
So here's what I don't understand, though.
Moves at warp speed.
And I don't mean to interrupt you.
I just want anything. Those are the facts.
No, I don't want to interrupt you. There is a special counsel investigation into the current president and his handling of documents. I think that if you want to look at the differences from what we know right now, and you've made this point in the past, and it's fair, we don't really know what's going on with Robert Hur, the special counsel's investigation. But we do know that the current president, appeared to have voluntarily turned over documents, which I think is a pretty stark difference in this case specifically. But I also think when you mentioned the Clinton case, the president is literally quoted in this indictment saying that he appreciated that the lawyer, Hillary Clinton's lawyer, deleted the 30,000 emails or made an effort to, and that she didn't get any trouble because he said that, and he was the one who deleted them, and basically said that was a good thing, and that was helpful to some degree.
Look, let me respond to that in this way. You have a situation here where now it's apparently this audio that's being talked about, that frankly, this audio transcript, let me say this, that's being leaked from the Department of Justice. That's not being leaked from anybody else. And by the way, last time I checked, leaking information in a criminal probe, that is also a violation of the law. So that stuff is being leaked to the press. CNN, you guys picked it up first, and it's gone on from there. I don't know the context of that audio. And even in this conversation, I don't know the context of that, because an indictment is a one-sided argument. That is all it is. And that's why you actually have a full proceeding in front of a judge where defense counsel gets to go back and forth. I think from a political perspective, the way a lot of Republicans and frankly a lot of Americans are looking at this is they're basically saying, well, damn, if you're Donald Trump, they're going to come get you for anything. But if you're Hillary Clinton or Joe Biden, they're going to investigate very, very slowly, and let's see where it actually ends up. That is not good for the United States of America.
Congressman, I appreciate your perspective, and it's a very important one, that the defense has not laid out their response to this yet in detail or in court, and they certainly will have that opportunity. Congressman Byron Donalds from Florida, thanks so much, sir.
Thank you.